Get ready for the dictation. Dictation will start in 5 seconds. Start. There is no dispute that the case at hand is a case of death of the sole plaintiff and is governed by Rule 3, Order 22 CPC, and which provides that upon the death of sole plaintiff and if the right to sue survives, the court, on an application made in that behalf, shall cause the legal representative of the deceased plaintiff to be made a party and shall proceed with the suit. That is in brief what sub rule 1 of rule 3 of order 22 CPC provides. Sub rule 2 further provides that where within the time limited by law no application is made under sub rule 1, the suit shall await so far as the deceased plaintiff is concerned, and on the application of the defendant, the court may award to him the costs which he may have incurred in defending the suit to be recovered from the estate of the deceased plaintiff. A reference to Rule 9 will also not be out of contest, and which provides that where a suit awaits or is dismissed under this order, no fresh suit shall be brought on the same cause of action. Sub-rule 2 of Rule 9 further provides that the plaintiff or the person claiming to be the legal representative of a deceased plaintiff or the assignee or the receiver in the case of an insolvent plaintiff may apply for an order to set aside the abatement or dismissal, and if it is proved that he was prevented by any sufficient cause for continuing the suit, the court shall set aside abatement or dismissal upon such terms as to costs or otherwise as it thinks fit. The procedure requires an application for the making of legal representatives of the deceased plaintiff or defendant a party to the suit. It does not say who is to present the application. Ordinarily, it would be the plaintiff or his heirs, as by the abatement of the suit the defendant stands to gain. However, an application is necessary to be made for the purpose emphasis supplied. If no such application is made within the time allowed by law, the suit awaits so far as the deceased plaintiff is concerned or as against the deceased defendant. Admittedly, the plaintiff died on 2/11/2004 and the suit got awaited after the expiry of 90 days therefrom. It is not necessary to have an order passed on record dismissing the suit as awaited. Certainly, the legal representatives of deceased plaintiff could have moved an application to seek the abatement set aside, and that had to be done in the next 60 days, and if not within further period, by explaining the delay in filing such application. If the suit had awaited after 90 days of the death of the plaintiff on 2/11/2004, there was no caution in my opinion of filing any application for transposition of the said defendant number 3 and 13 in place of the deceased plaintiff. The matter of transposition is dealt by Order 1 Rule 10 CPC, which is a general remedy. Defendants number 3 to 13 were already proceeding ex parte by virtue of orders dated 15/1/1997 and 19/4/1997. The said defendants filed an application for the first time on 14/3/2006 to transpose them in place of deceased plaintiff, and after realizing that they were already being proceeded ex parte, they filed another application dated 6/7/2006 for recalling the order proceeding ex parte against them. The said defendant did not even file any application for condoning the delay and only made a casual statement that in case there was delay, the same we condoned, full stop.